Welcome everyone to this new episode of our vlog series. I am Alessandro Tacconelli, PhD candidate of the Center for Law and Economics here at ETH Zurich. In a judgment rendered more than 1 century ago in 1883, the US Supreme Court specified that no person is above the law. Every officer of a government from the highest to the lowest is a creature of the law, and as such is bound to obey by it. Everyone in most contemporary legal systems would agree with this fundamental principle. Politicians, as everybody else, should not be immune from criminal prosecution. Unlike for everybody else, though, the decision to prosecute a politician, especially in a system like the one of the US, may be influenced or may be seen as influenced by partisan politics. But then, how can we ensure that the decision to prosecute a politician fulfills its purpose to punish lawbreakers without being driven by the impetus to punish political adversaries? I'm very happy to have here with me today Ian Ayres, Oscar M. Rubenhausen Professor of Yale Law School and Yale School of Management. Professor Ayres' research interests are particularly broad, ranging from contract and corporate law to LGBTQ+ topics, behavioral law and economics, and tax, just to cite a few. Today, we will be discussing about their article, How to Legitimate the Prosecution of Politicians. Welcome, Professor Ayres.
Great to be here.
So, Ian, before we delve into the discussion of the article, why don't you give us a brief summary of its background and content?
Saikrishna Prakash and I propose that before a politician is subject to indictment, that there must be agreement from a prosecutor's jury that would be composed of 20 former U.S. attorneys that were randomly chosen. 10 would have to have been nominated by a Republican president, 10 by a Democratic president, and that you'd have to get at least 2/3 of these 20 members to agree that indictment was appropriate.
Thank you so much for this summary, Ian. So, in your framework, you rely on the professional nature of the prosecutor jury, right? So, since you suggest that since the supermajority of professionals representing both political parties is needed to endorse the potential indictment, Americans will most probably value the indictment as not only just but also appropriate. But can we be sure about this? Think about the recent case of handling COVID-19 situation, right? Their expert opinions often clashed with public sentiment and personal views. But then, can we truly be confident that those expert opinions of a prosecutor jury will translate into public perception of justice and appropriateness? And if not, how can we reconcile this disparity between those expert opinions and the public perception in the context of your framework?
Yeah, it's a difficult problem that in order to gain public acceptance, you have to have the public trust some entity, some process. And, in the past, they would just trust individual prosecutors or the Justice Department. But we're at an age where trust in public institution in country after country is coming under attack. And so instead of the search for a philosopher prosecutor that stands outside of politics, this is instead an approach that leans into politics. And in our proposal for the United States, we've suggested having a politically balanced and randomly selected group of former prosecutors to try to ensure some appearance of justice. And we choose former prosecutors because, one, they have experience doing prosecution, and secondly, they are political notables. They go on from this powerful position to other powerful positions. And particularly if we're in the United States and we're thinking about whether it's appropriate to prosecute a former president, these former U.S. attorneys, they go on to be Supreme Court justices, attorney generals, governors of states. They're well known. Their names are known to a large number of Americans. But still, your question is a deep one. We're at an era where anyone who criticizes the former president, Donald Trump, is immediately categorized as a rhino, a Republican in name only. And so it may be that there is no way of convincing a broad swath of Americans, particularly of diehard Republicans. But this is an effort to try to find a group that is credible and potentially convincible when it is appropriate.
Thank you so much, Ian. So another relevant characteristics of your prosecutor jury, as you said, it's political balance, right? So again, in light of the supermajority rule and the way in which its members are appointed, that is equally representing the US political parties, this should, in theory, avoid partisan prosecution against politicians. But then, how does this relate to the evolution of political parties, especially in the US context, right? Because after all, attorneys that are appointed in the more distant past may now hold views that are particularly diverging from the ones held by the appointing party today. And so again, you mentioned now, and you also mentioned in the article, the case of President Trump, quickly just labeling Republicans criticizing him as Republican in name only. Yeah. And so cannot we say that Republican-appointed U.S. attorneys today may still be biased against Trump, notwithstanding Trump's political association?
Yes, we can say that, and I'm sure that there will be, if this ever came to pass, there would be people that would say that. You know, another version of the proposal might say that you have to choose the Republican members of this prosecutor's jury would have to be not just former U.S. attorneys, but former U.S. attorneys nominated by Donald Trump. That would come closer to, but then of course, even there, Donald Trump would say, no, those have turned against me, as Trump has said about so many of his former cabinet members, and including his former Attorney General, William Barr, who is, by the way, also a former U.S. attorney, Rudy Giuliani, former U.S. attorney, Jeff Sessions, former U.S. attorney. So there are many people that searching for a group of credible people of the same current political party is one that reasonable people could differ. But it's also the case is if you only say, no, this has to be from the smallest, tightest group of loyalists, then you get to the other problem is, are they actually people that we can trust to come to a reasonable decision? Will they just say, I don't care what the evidence says, we're not going to indict Trump or whatever or Netanyahu or whatever the political person is that is being considered for indictment.
Thank you, Ian. In the last part of your article, you mentioned a survey that you ran with U.S. attorneys to try to collect evidence corroborating the claims of your framework and proposal. Why don't you tell us more about this survey, maybe how the results look like, but also any obstacle that you may have encountered along the way?
Sure. So to try to get us a little simulation, a slight simulacrum of what this prosecutor's jury might do, Sai and I went out and we attempted to contact all the former U.S. attorneys from Trump all the way back through Ronald Reagan. And this was there is a universe of, I believe, over 500 former U.S. attorneys. So it's a rich set. We could find contact information on over 400 of these. And we reached out and asked them in two different waves whether Donald Trump, whether it was appropriate to indict Donald Trump. In the first wave, we asked with regard to the 4 referred charges that came out of the House committee. And in the second wave, we asked about the New York state indictment and the Florida federal indictment. And the most important thing that I should emphasize is that our response rate was quite low. And so reasonable people could say with a response rate of just about 10%, you might just ignore everything else I'm about to say. But with that very important caveat, there, I think, was some heartening news. First, these former U.S. attorneys that were nominated either by Democratic or by Republican presidents were nuanced across the different charges, that they didn't, and they were nuanced, they didn't show complete political bias. It's not that less than 100% of Democrats said he should be indicted in all of these charges, more than 0% of Republicans. So some Republicans said he should be indicted, some Democrats said he shouldn't, and that it varied across the charge. And interestingly, the Florida documents case, a federal case saying that Trump obstructed justice by not turning over classified documents, that was the one indictment that we tested on that met our predetermined standard of 2/3. And so in order to meet that standard, we needed to get more than a third of Republican-nominated U.S. attorneys to support that. And this was, in our balanced jury, more than 75% of the Democrats and Republicans together said that indictment was appropriate.
Very interesting. Thank you for sharing your research with us today, Ian. As the last question, maybe we should still discuss about the practical implementation of the prosecutor jury within the concrete legal system of the US, right? So in light of the principles and regulations of the US legal framework, do you see any obstacle to the implementation of your proposal?
Yes. One obstacle is the US federal system. There are 2,400 prosecutor offices throughout the United States. And already we've seen with regard to Trump that both in New York State and in Georgia, a former president has been criminally indicted. And I think there's every concern that we may very well see politically motivated criminal prosecutions in the future. And so one obstacle is how to subject this vast group of state prosecutors to some kind of discipline to make sure that current and future politicians are not unreasonably harassed.
Thank you again, Ian, for being with us here today. We look forward to your future research and contributions. And to our vlog viewers, we hope you enjoyed this episode as much as we did, and see you next time.